So it's now 10 o'clock and the inquiry's resumed. So in terms of the matters that I just want to deal with in terms of housekeeping before we move on to closing submissions, I understand UK AEA wished to make a statement in response to Mr. Mokler's evidence yesterday. I've received the plan from RWE setting out where the access points are. I think that's been added to the website, and if not, it will. It was discussed during the inquiry. Is it Mr. Trigg?
It is Mr. Trigg. I'm not sure I've seen that plan yet, but if it's just that,
it's just a few coloured circles. There's no commentary. So if that's not on the website, it will be added to the inquiry website. I'm awaiting, there was something from Thames Water, a constraints document. They said it would be here by Friday, thinking we were closing tomorrow. I'm just trying to find the programme officer has let them know that we were going to close today, but actually because we're holding the inquiry open, it should be fine. I'm just trying to find the document. Sorry, Joanna, was it copied to the parties? It was, so you've seen it.
It's the constraints.
I think there's a document that Thames Water put in, which is not the constraints document. It relates to, it relates to their sort of enhancement plan and things of that sort. It's about 3 or 4 paragraphs long. We saw that last night and can deal with that in our closing. The constraints document, which was promised when Thames Water appeared, some 2 weeks ago, we have not seen. I don't think it's been produced yet.
Hasn't been submitted yet.
Yes, the problem with that we obviously need to think about is if that is going to be submitted after we've all left today, how do we deal with it?
I think what they've suggested is they'll share it with you first before they forward it to myself or to the programme officer. It should be here today or tomorrow.
Right.
And then that gives you a week to, if there is anything you need to say in relation to it.
If we have an opportunity to comment on that would be helpful.
I think that's reasonable, that you have a week to comment on it. I think, sorry, Joanna, it hasn't come in yet, has it? No. Hopefully it will be here today, but it might be here today after we've left as well. So that's what I propose to do. We've got the deadline of the 17th for formally closing the inquiry, and I think if I can stick to that, but obviously the Thames Water document needs to be here by tomorrow to give you that opportunity to deal with it. So if there's any delay there, we'll let you know, but I don't anticipate a delay because they said, struggling to find the correct email, that it would be there for Friday, be with us for Friday. And we did remind them yesterday that it would be today.
Thank you, Madam.
Okay, so that's the... Right. There's also been correspondence on Mr Templin's suggested condition, in particular that it's not included on the schedule. I'm not too concerned that it's not considered on the schedule itself because it's on the inquiry website regardless, and it will be addressed and reported to the Secretary of State. What we've done, there's been the comments from both the applicant and the local planning authority. So the final email we had was Mr Perriam's, and we've added as Q11 that email trail so that it's got all three responses, Mr Templin's point and the the applicant's comment on that, and then the local planning authority's comment. So it will be covered even though it's not in the schedule. I don't think we need to reproduce the schedule. Don't think that serves a useful purpose.
Thank you, Madam. In general, I'm happy with what you've just said, but I would ask if you could, when considering the suggestion that I made, also check what Mr Perriam actually said at the inquiry, which is recorded on the video in response to when I put the idea put forward. I can't give you a precise time for that, but it is very clear from what he said at that time. I think it's on the 23rd of April.
Mm-hmm. Thank you, Mr Templin. Mr Humphreys, did you have anything to add?
No, the schedule that we put in, as I hope was made clear in the follow-up email, wasn't purporting to be an agreed document. It was just setting out our position on things and you know, incorporating or commenting where appropriate on some of the things that other parties had said. It doesn't include Mr Tamplin's proposed condition because that's not one that we think is appropriate for the reasons we discussed during the condition session. But obviously, as you have rightly said, that's before you, and you will obviously need to consider whether or not it is appropriate to impose that.
Thank you. So the next thing I've got is the modifications. I've got those here. And then, sorry, I need to turn that off now. Then it's closing submissions. So we've got closing submissions from Mr Mockler, and we've got closing submissions from the council.
Sorry, there's one more housekeeping matter, if I can just raise it,
Certainly.
which is the proposed condition in respect of RWE. You have yesterday's was discussed what was proposed by the council, and you also had Mr Perriam's comments on that in the condition schedule. Yesterday evening, RWE came back to us on that condition. In brief, what they said was that they'd, for whatever reason, hadn't spotted the email which was sent last week until a reminder was sent last night. And they've suggested some amended wording to that condition, which we've had a look at and we are content with. What I've got is it's an email from RWE's solicitors, which explains the background a bit, has their amended wording, and therefore I've got a hard copy now. Perhaps I could just hand it up, and then we've also sent it to the programme officer. So could I just hand that up and explain it?
Thank you. Lovely, thanks.
So in the second paragraph of the email, you'll see that RWE, in fairness, they say they don't feel it resolves their objection, but they are. You see the third paragraph, generally supportive of the proposed wording, and then they make some amendments in red, which is an amendment to the second bullet point regarding access, and they've added an additional third bullet point, which is essentially road specifications, not gravel, minimum 7 metres wide. And we've had a look at that. The relevant highways designers have had a look at that, and we are content with that amended wording. And so rather than amending our condition schedule that we provided yesterday, what I was just proposing is that this email goes in and our position is recorded that we're happy with this wording. But obviously, if you prefer an amended condition schedule, we could provide that.
No, I think it's easier to manage as a separate email.
Thank you.
Thank you. Does it have implications for any of the orders? I don't think it does.
No, it doesn't.
And in terms of any of the plans, the general arrangement plans, etc.?
No, it doesn't. It's simply part of essentially the construction environmental management plan, providing some extra detail and requirements. I should also say that this is obviously an email from RWE solicitors to us. We have explained the fact that it's being provided to the inquiry to RWE solicitors, so they're aware and they are content with that approach.
Thank you. And it also says that they may provide further comments today, but that they're generally supportive of the proposal.
It does say that. That we've had no further comments yet, and we've had further email correspondence with them this morning, and they haven't proposed anything. So obviously, I can't speak for them, but I can certainly say we haven't had any additions since this email.
Okay. Thank you for that. And in terms of, so I've got updated schedules for the orders. In terms of the planning conditions, I asked very early on in the process for a list of the documents to be approved on which we should consider the appeal. And I think it's the supplementary statement of Common Ground Q2 that provided that list. Was that a complete list of conditions? So the documents there, do I have a list of the documents that should be approved if I was to recommend planning permission be granted?
We think you might have within condition 2 itself.
It's actually in the conditions, is it?
I might need to just check.
Has the updated conditions document, is that on the website? It probably is, and I'm just missing it.
It's not on the orders section. No, I don't think it is yet.
It's just we're putting them all under Q, and I'm not sure if it's gone under Q.
Yes,
so if I go back to so it would have been in the original document. Yeah. So the document we saw yesterday, and I saw it online, Are you saying that's been put in the orders? Or?
No, I think what we're saying is that the document, the conditions table that went in yesterday, which was the subject matter of the exchange of emails, is not on the inquiry website. It would naturally fall within the planning
Absolutely.
part of the website, so the INQ rather than the O-INQ series of documents, because it's a planning document, not an orders document. But it could go in the CDQ series, but it is a document that was submitted during the course of the inquiry.
So was it condition 2 you suggested, Mr. Flanagan?
Yeah, so it's condition 2. Approved documents and drawings which include, and then there's a long list of bullet points.
It should not be other than. So is it the version I've got here doesn't show that. So is it on the version that came in yesterday?
It is on the version that came in yesterday,
Right,
yes.
so that will be an email. Okay.
In the version that came in yesterday, it's in the extreme right-hand column.
Thank you. Right, okay, that's fine. I hadn't picked up on that.
The penultimate right-hand column says OCC view, condition 2 needs to include list of approved drawings and documents for clarity as to what is approved, etc., and then the right-hand column says OCC suggested condition wording, and that's the one that has the bullet point list to which Mr. Flanagan referred.
Thank you. Right, so I think that's everything on conditions. Unless there's anything else, conditions for the planning inquiry. So should we hear from UK?
Madam, sorry, nothing
Sorry.
further on conditions, just only because you haven't mentioned it, I think, orally, there would, in terms of public rights of way, there were 2 notes submitted this week. One is on the inquiry website as OINQ13. I assume you've seen that. It's simply a note kind of identifying more precisely where the rights of way that were discussed last week are.
Sorry, Q13, did you
No, sorry, OINQ, so orders
INQ,
INQ.
sorry. If you bear with me. So that's the note on the public right-of-way.
Yes, and I was just raising that because it hasn't been mentioned, but it's there and hopefully relatively uncontroversial. And on that same theme, there is, you'll recall that you, I think, received a email dealing with the updated numbering for the rights of way south of the A4130. A further revised version of that note has been subsequently produced because one of the rights of way, a further one, the numbering is now formally changed.
And that's within these modifications for this morning. Is that
right?
Yes?
That is correct.
Right.
That note I don't think is on the website yet, but it was submitted yesterday afternoon, so hopefully will be shortly.
Have a look.
Currently there is OINQ number 4 was the original version of that note, and that's the one that's been updated yesterday, but yet to go on the website.
Right, I don't think I've seen the most recent note, but I think... Okay, well, I'll make sure a copy of that note is added to the website. I've got the updated schedule here, which is, I think, the document on my desk, but I'll make sure that one is added to the website. I'm assuming it's just saying that the number's been updated.
That's correct.
Reflecting the discussion yesterday. I think you raised it, didn't you? Okay. Sorry, Mr. Flanagan. Is there anything further? I think if we hear from UK, I always get the EAA. Yeah, sorry. So I think if we hear from them first, and then I think I'm probably happy, but it might be as well just to check it while we're here. And so I think that's what I'm proposing to do. Is there anything else to be handed up or said at this point?
No, thank you.
Good morning, Madam. Since yesterday you advised us that today we could make some response to Mr. Mann's most recent evidence, I've consulted with colleagues, and I think certainly Mr. Harman would like to do so, but he can't be here today. So what we would like to suggest to you is that he or anybody else who wishes to make a statement can provide a brief written description, a brief written commentary on that evidence and submit it within a few days to you.
It was my intention to close the planning inquiry today. We did say at the beginning that you could make closing submissions in relation to that, to make the commentary on it when the witness wasn't cross-examined on it. I think that's quite difficult to accept, Mr. Hancock.
Okay. We note that one or two documents are now to be submitted after today. And,
sorry?
We note that one or two documents have been suggested to be submitted after today. I appreciate that it's perhaps it's stretching a point, but we would be pleased if we could circulate such a brief note commentary on Mr. Mann's evidence to all parties, and if that was acceptable, then we would see if we can do that fairly quickly now.
The documents that I've agreed could be submitted after today are documents in relation to the orders inquiry. Mr. Humphreys, do you have a view?
Yes, Madam. I don't consider it's appropriate to submit what, from the way it's been described, seems to be a form of rebuttal evidence. You've said because of objections in relation to May's properties and Gale Trust, legal agreements may not be signed allowing them to withdraw their objection, that you would give until the 20th of this month for that to happen. That's not further evidence, that's just withdrawal of the withdrawal of the objections to the orders. Thames Water have said when they were here 2 weeks ago that they just wanted to produce a note on constraints on their land, which arose when they were giving evidence, and because originally I think they thought the inquiry was going to close tomorrow, they'd programmed that for tomorrow, and you've said because we won't have seen it, that we could just briefly respond to that. That is wholly different from the neighbouring parish council's joint committee or other parties, Rule 6 parties, responding to Mr. Mann's evidence. They were here, they could have cross-examined Mr. Mann if they had wanted to, and so I can't see that that can be proper at all.
Okay, Mr. Hancock, my view on it is it would be unreasonable and procedurally unfair to allow you to submit that, because they weren't questions that were put to the witness and could be addressed in re-examination. We were very clear that you could do that if you wished during the inquiry. So to put comments in now, I would have to hold the inquiry open, give the council an opportunity to respond, and then further closing submissions. So I'm going to say no. If you wanted to make a closing submission in relation to that part of the planning inquiry, that would be acceptable. But to put further comments in at this stage is unacceptable, and I'm going to say no.
Okay, thank you for your advice, Madam.
Thank you. Is there anything else before we move on?
Yes, please, Madam. In relation to what you have just said in response to Mr. Hancock, I wish to raise the same point in relation to poets, because as you know, poets were not a party to the CPO inquiry, but we were a Rule 6 party for the planning application and its inquiry. And I wish to make, on behalf of poets, I've called it in my note a response, but it is in fact closing submission on the point of Mr. Mann's note of the 26th of April.
It wasn't, Mr. Templin, part of Poet's case on the viability, was it? That came from the parish councils.
I think I'd understood you to say that poets, as well as the parish council, and I believe Mr. Turnbull on behalf of East Hendred Parish Council, also raised the issues in their evidence.
So are you able to, so these are closing submissions in relation to what we've already heard from Mr. Mann?
Yes, I am.
Mr. Humphreys, do you have a view on that?
Madam, yes, if what Mr. Tamplin wants to do is make a closing submission as an advocate, then I have no objection to him making a closing submission of an advocate. He needs to understand, however, that what he says, unless it is summarising evidence, is not itself evidence. It's not evidence at the inquiry. It is, like anything I say, simply an advocate's closing submissions. So there isn't an opportunity to have another go at the evidence.
Thank you. What I propose to do is take a 10-minute break. It might be that you wish to talk to each other over that break and agree what it is or isn't going to be presented to the inquiry. I'll come to you in a minute, Mr. Merkler. Can you, Mr. Tamplin, forward it to the programme officer, what you intend to say? And I don't know how long it is. Do you have hard copies?
I'm sorry. I have only 2 hard copies simply because of logistics. I was not aware until last evening that this might be possible to say this morning, and frankly I ran out of paper early on this morning, very early this morning, and I've only got 2 hard copies here, one for you, madam, and one which I wish to refer to, but I can certainly send an electronic copy to the programme officer immediately.
Okay, so what, as I said, what I'll do, if I take a 10-minute break, and if you could have a word with Mr. Humphreys over the break, and then let me know what the position is. But I do share Mr. Humphreys' view, and I'm sure you're aware of it, that it's not a time to submit new evidence. It is summarising your position at closing. Okay.
I understand entirely, madam. My experience would confirm what Mr. Humphreys has said, and I don't disagree with his
I'm
point.
sure you do. Okay, so if we come back at about 22, and if Mr. Flanagan or Mr. Humphreys could have a word with Mr. Templin and just see. Thank you. Sorry. Now, and then we'll take a break.
Right, okay.
Okay.
So my closing submission, and I do apologise to you, madam, and to everyone else if I won't be here to hear
It's not a problem.
the rest of the evidence today, which I've always been very interested to hear everyone's point of view. Another apology. I was. Mrs. Vincent told me last night, I thought I'd shot my bolt yesterday, and Mrs. Vincent told me last night that I could make a closing statement today. So it's handwritten, because I only did it this morning. Right. 7 points. Point 1. Let me be crystal clear on this vital point. The landowners of Milton Fields are not interested in and will not accept anything other than a basically car-free development. They're not particularly interested in profits, and I hope you'll take my word for that. What they're aiming for is a legacy development of 800 carefully designed houses in an almost self-sufficient, traffic-free community. Point 2, everyone, or almost everyone, agrees that houses need to be built, and that reasonably quickly. Point 3, how regrettable it is that the decision of OCC's planning committee in July last year, when they voted by 7 votes to 2 to refuse the Hi-Fi scheme, was overturned. Had it been accepted, then Milton Fields would be going ahead at full steam with discussions with planners and hopefully building starting early next year. But as it is, there will inevitably be months of delay, madam, while we await your decision and then that of whatever secretaries of state are in power in the future. It all seems a great waste of time, money and efforts, quite apart from the mental strain involved. Point 4, Clearly, a car-free development is not for everyone. But in many countries in Europe, it has been shown that there are people who want to live in a car-free neighbourhood, such as, for instance, Freiburg or Portbou, or indeed Lemnos. Point 5. There is no compelling case for dualling the A4130 between Milton Interchange towards Didcot, whatever the merits or demerits of the rest of the Hif1 scheme are. Point 6. Indeed, if you, madam, were thinking of buying or renting a house in a car-free development, I'm not suggesting you are, you probably will want to wash your hands of the whole affair after all this. Would you not waver if you saw that facing your car-free house and street or square was a 4-lane dual carriageway with thunderous HGVs using it, to relieve pressure on the A34, as I am told by Mr. Hancock, Mr. Blanchard suggested, as of all things, a benefit yesterday. You surely would waver if you were thinking of buying or renting a house in Milton Fields, if there's that going on. Point 7. Indeed, there is a compelling case for not dualling the A4130 and therefore for not compulsorily purchasing our land, in the sense that doing so would risk the whole scheme of 800 houses allocated to Milton Fields not going ahead at all, completely contrary to the, can't read my own writing here, to the declared aims of Homes England, and the funding is given for its purposes. Thank you, madam.
It's very concise, thank you.
And if you'll excuse me.
Thank you. So we'll take a 10-minute break now, so that takes us to just before 10 to, just before 10 to. Okay, thank you. So does somebody want to update me?
Yes, Madam. Mr. Tamplin wants to make a closing submission. I've said I have no objection to him making a closing submission. I've just been emailed a copy of it, and I've just very quickly gone through it, but that's absolutely fine. The programme officer has asked if I need longer to go through it, but obviously, in a sense, I'm going to hear it orally as well, so that's absolutely fine.
Thank you. Before we hear that, I think I'd like to hear, is Mr. Kavanagh? Thank you.
Thank you, Madam. Yes, and to properly introduce myself this time, because I completely failed to do it last time I spoke to you, so I do apologise. My name is Peter Canavan. I'm a chartered town planner and a partner at Carter Jonas, brackets, neither a land agent nor estate agent, as I was labelled yesterday. Mr. Moakler yesterday made several inaccurate, misleading comments about the UK AEA. This was at the wrong stage of the inquiry. We were not here. Didn't need to be here. We didn't think. We were not intending to cross-examine him. We therefore didn't have that opportunity, and neither have we really seen what he said in writing. So what we've got are his comments that were not put to Professor Sir Ian Chapman, neither to any of the other UK AEA witnesses. But having said that, from the listening that I was doing via YouTube and the live streaming yesterday, and from what we've been able to glean so far, there doesn't appear to have been anything that really was different to what other witnesses were saying, or indeed what Mr. Moakler has said at local plan examinations, particularly the Vale of White Horse. So I think that most of what he said in terms of the UK AEA's case, we have responded to already in our closings. But given it was yesterday and I've only seen it on YouTube and we haven't seen a written version of what he said, I can't be 100% sure on that.
So his his actual proof is on the website, and he read quite a lot of that. It's only 2 or 3 pages, I think.
Yes.
But obviously he deviated a bit.
Yeah, that's what I mean, and the opening parts, and thank you, Madam. You reminded him where he was drifting into the planning points, and so I think we've probably got 2 courses of action here. I think if we need to respond, we can in writing, but we can't do that today. I'd beg perhaps a week, because it's Professor Sir Ian Chapman's evidence that was challenged. We need to get him to look at what we're responding to. He's a challenging man to get hold of, and I think that, as I say, that would probably take us about a week to get back to you. I'm conscious of the conversations that were had just before the break there, and that you would like to close planning matters today. So I suppose the alternative is that there is confirmation from you that comments on UK AEA from Mr. Moakler will not be reported to the Secretary of State.
So I think I favour the latter. I think some of the comments clearly weren't relevant to the points that Mr. Moakler was making. I've got his proof, and I've got my note from the time, but there were comments there that he probably shouldn't have made about people and things, and that's not noted down. I've focused on the points that I can use in my decision.
thank you. And I had no doubt that you would. So thank you very much. And I think it's more that it was particularly because it was live streamed, it's on YouTube as a point of public record in that sense, that we, or the UK AEA, excuse me, needs that opportunity to point out that what he was saying was wrong, and that in our evidence we had already explained where what he had said was wrong. So thank you.
Thank you. In terms, while we're at this point, in terms of Mr. Mokel's evidence, it's all on the orders website, but because of some of the points he made, I think it would be appropriate to replicate that, just copy it en masse onto the planning website, because there are points, some of the points he made. Mr. Page, we discussed yesterday and said that would go on the planning website. I don't know if the parties have a view on that.
If I might very quickly, just that if it's going onto the planning website, and we'd need to double check what it says about UK AEA and whether we'd need to respond in writing.
I'm not sure in his proof that he does.
No, I didn't think it was either, but if I can double check that while people are speaking, if that's okay.
Yeah, there's a copy here if you...
Yes, please. Thank you very much.
I've got 2 copies. It's, there you go.
Can I say in the meantime that for our part, we don't have any objection to that proposal. It seems sensible. And also, we've responded to Mr. Mokel's case and evidence in our submissions for the orders inquiry. To the extent that some of that evidence may have stretched into planning matters, the response is still there in the closing, so you have it.
Yes, I mean, the reason I think that it would be sensible to have it on the planning site is that if the Secretary of State for the orders has got issues and they're not addressed in the planning evidence, that might be in the planning decision.
Yes.
Might be an issue. I think the only new point there probably was the duelling. To me, that's the significant one without checking back through everything.
It is. I think you're right, and our closings for the orders deals with that point in a bit of detail, as you'd expect. Mm-hmm. And I suppose the only point I might make is that what we say in our orders closing on that point, to the extent that it's relevant to the planning decision, we'd ask that to be taken into account for the planning.
Absolutely. Yeah. I think it was just he probably hadn't picked up the distinction between the 2 inquiries. I don't think it was intended. It's my feeling. So... If I just give Mr. Kavanagh a moment. Oh, you've...
Thank you. No, I've read that. Yes, there's nothing on there about the UK AEA, and I think you're right. It makes perfect sense to put it with the planning evidence. And I think, as I said earlier on, what he said yesterday, whilst not challenged directly by us, of course, because we weren't here, I think that we did properly respond to in closings and in evidence. And if those notes aren't part of, if you didn't note what he said, as you say, so I think that in that case we are content and we don't need to put anything further in writing. But thank you very much.
Thank you. Obviously, he did have other documents, but they're just different reports that you'll see on the website there. That's the proof. So on that basis, is there anything additional that you need to add? No?
I don't think so. I will double check if that's okay. But
Thank you. So I think probably the best way to proceed from here is if we hear the closing from Mr. Tamplin in relation to the planning inquiry. And then if the council wants to add anything in terms of their closing to the planning inquiry, then we'll do the modification. And we'll then have a short break before we hear the council's closing. And over that break, perhaps somebody from the council could just check with the programme officer that everything that should be on the website or in the process of going on the website, that we've not overlooked anything, essentially. I think it's easier to do in person than through emails later. So that's how I'm intending to proceed. Is everybody happy with that? Yes? Okay, so Mr. Templin, you said you had a hard copy?
I do indeed, madam.
Thank you. Thank you. Whenever you're ready.
Thank you, madam. Firstly, my apologies to Mr. Humphreys and his team that I didn't have more hard copies available to them. I've made a couple of very minor changes to this because I didn't finish it until about 8 o'clock this morning, and then I had to get ready to come here. So the first change is the title page, which I have seen on your, you will see on your hard copy. I've amended from Poet's response to Mr. Mann's note to Poet's closing submissions in response to Mr. Mann's note. The second is at paragraph 5, line 3, where the word white should, of course, be might. And the last correction is 4 lines up from the end of paragraph 6. It says the line starts security in the wake of, and then the words the financial problems of large local authorities. Those are the only corrections I can see so far.
Thank you. Would it be possible, Mr. Templin, later to just send an amended version to go on the website?
Yes, yes.
Thank you. And we'll just substitute. We won't give it a different number.
Yes, thank you very much. Thank you. The funding position of the scheme is a further example of the smoke and mirrors approach of the applicant to the evidence given to the inquiry on their behalf throughout the proceedings. It appears to clarify the position on funding by introducing more uncertainty and raising more questions than it answers. This is illustrated by reference to paragraphs in Mr. Mann's note as follows. Table 2 in paragraph 2 of the note shows 4 funding streams for Hif1. I won't read them all out. All bar the last, developer contributions, originate from the public purse. The exception was at the date of submission of his proof, 30th of January this year, £16.4 million, or about 5.5% of the total funds available, which were £296,155,000. In his note, paragraph 3, Mr. Mann gives the projected costs of the scheme at that date as being £332.5 million. This is confirmed in his note, paragraph 6, as the total of the 4 funding streams. This figure is £36.4 million higher than the estimated scheme total costs, and is the sum of additional funding agreed by Homes England cover the revised inflation budget. As a result, the developer contributions, which remain at £16,442,000, is now only 4.8% of the scheme total costs. The purpose of building Hif1 is, according to all the evidence given by the applicant, to provide the essential highway infrastructure to enable the building of about 20,000 additional dwellings in and around Didcot, in line with the adopted development plan allocations for both the Vale of Whitehorse and South Oxfordshire districts. But those developments will make a contribution to all the services and facilities to be provided for the occupiers of those dwellings at a rate of less than 5%. And as paragraph 5.18 of Mr. Mann's proof explains, while some of the Section 106 developer contributions are secured, others are non-secured and have to be underwritten by the council. If this scheme was being proposed in an area of England where the property, the word market should be there, the property market was depressed and sluggish, this exceptionally low rate of developer contributions might be understandable. But Didcot and its surrounding areas exhibit no such signs of housing market failure, and the applicant has put forward no evidence whatsoever that it is or might become such an area. Instead, it seems that the scheme is simply offering a huge financial subsidy to house builders and other developers in this part of Oxfordshire for no reason which could be seen as being in the public interest. No doubt the press and the public, were they to be informed by OCC of the true financial commitment they have been tied into, might reasonably term this subsidy a bung, or in Mr. Mockler's words, a large dollop of wonga to those developers. But it may become even worse. Poets would also point to the absence of information or evidence in Mr. Mann's proof on any further funding which the scheme may require. Thus, the final bullet point of paragraph 6 of the note says that Homes England has also provided the ability to, quote, access significant additional contingency beyond the additional £36.4 million already declared if required. Similarly, bullet point 3 of paragraph 7 of the note refers to a, quote, a number of conditions having been included in the offer, but gives no explanation or outline of what those conditions contain. Because this is public expenditure, the public should be given at least an outline of these conditions and how they may affect the viability of the scheme itself, and whether they may affect the financial viability of the County Council itself. Given the increasing concern over financial security in the wake of the financial problems of large local authorities in the past few years, this concern in their security cannot be dismissed as irrelevant or mischievous. It is a matter of legitimate concern and transparency, something of which the County Council is either unaware or indifferent. This unknown commitment is said by Mr. Mann to have been, quote, considered by no less than 5 government departments or agencies. That's in note paragraph 7, bullet point 1. Of those 5, 2, the Department for Levelling Up, etc., and the Department for Transport, are directly involved in the process of also considering the scheme as a planning application and as the subject of a compulsory purchase order, respectively. Those two departments are therefore to be judge and jury in their own case. Poets hope that there are very strong, unbreachable Chinese walls between the two different functions involved in consideration and approval of the planning application and the CPO on the one hand, and approval and confirmation of the funding of those very matters. Of course, we realise that this is England and not Equatorial Guinea in the 1980s, and it would be entirely wrong to suggest that any such comparison could be made. But the perception in the eyes of those landed with paying the final bills, which now, at OCC's own admission, amount to at least £332.5 million and rising, is another matter. Poets are also aware of information from reliable, reputable sources that further negotiations may be ongoing between the County Council and Homes England to secure yet more funding, even beyond the additional contingency referred to in the final bullet point of para 6 of Mr. Mann's note. If this is the case, this deepens our concern at both the size of the subsidy being offered to developers at the expense and risk of the residents of Oxfordshire, and the unproven and unevidenced viability of Hif1. It also adds to our planning concerns that the scheme is an outdated and unnecessary proposal when a combination of smaller scale, sustainable transport options to proposed housing and employment development in and around Didcot would represent far better value for money and help to tackle the urgent imperative of combating climate change in accordance with the County Council's LTCP policies and proposals. What the whole sorry saga reveals is that this scheme was blundered into by OCC announcing several years ago how they were being awarded a huge sum of money by government to build a road scheme to enable the building of 100,000 homes across Oxfordshire. Those homes were, quote, assessed objectively as being, quote, needed by the same government. The geographical distribution of those homes was decided by a call for sites. That is, anyone who owned land and would be willing to sell it for housing could offer it to the LPAs to include that land in their development plans and contribute to the, quote, objectively assessed need of those LPAs. Hence, in southern Oxfordshire, we have ended up with a scatter of sites ranging from Dalton Barracks, 1,200 dwellings, and land south of the A415 in Marcham, 90 dwellings in the west, to land north of Bayswater Brook, 1,100 dwellings, and land at Wheatley Campus, Oxford Brookes University, 500 dwellings, and to serve the inevitable travel demand generated by many of that huge scatter of dwellings, the same tired response of the Highway Authority was to build another road, bigger and better, or so we are told. The response of OCC to the objectors and their cases has been nothing short of disgraceful. They have abrogated to themselves the right to put in any additional material they choose, while objecting strongly to any material the objectors wish to present to the inquiry. This has blocked and frustrated the rights of those objectors who are Rule 6 parties to the inquiry, as if they had no status in the process. The applicant has even gone to the length of interfering in a formal request under the Freedom of Information and Environmental Information legislation by releasing its interpretation of the answer in advance of the official reply. In addition, the County Council has sought to undermine the purpose of EIA legislation applying to this scheme by refusing to respond to a repeated formal request for the issuing of a letter under Regulation 25 of the 2017 EIA regulations for additional information on traffic flows beyond a tiny distance from the edge of the application site. Consequently, they have tried, we hope unsuccessfully, to prevent consideration of the effects of the traffic generated by the scheme on air quality and health in the designated AQMA in Abingdon and on outstanding heritage assets in Newnham Courtney. These perversions of the process are all reflections in the fact that much of what is required by the scoping opinion issued by the LPA has been ignored in the evidence to the inquiry as the case for the applicant. None of this disgraceful mess is a professional planning approach to how to relate housing to employment in what the applicant insists is still a rural area. The development plans and the plans for Hif1 instead reflect the greed and ignorance of politicians, developers, and most, but not all, as Mr. Mokler's evidence shows, landowners, putting personal interest before the public interest in the need for planning to provide green, healthy, lifetime housing based on sustainable travel and active transport as the first priorities in this unarguable and urgent time of rapidly accelerating climate change. We therefore reiterate our request that the application be refused for the reasons we have set out in our evidence, and ask that the order be not confirmed for the reason that it is not in the public interest. Thank you, Madam.
Thank you, Mr. Templin. These are your final closing submissions for the planning appeal, right? So, and the final part refers to the order. Thank you. Mr. Humphreys, do you want to respond to this now, or?
Yes, Madam. I'll do it now because obviously it's not in our closing submissions on the orders because obviously we didn't have it at that time, and nor is it in our general closing submission on planning. First point to make, obviously, is that these are Poet's closing submissions. This is not evidence. Second general point to make is that although Poets and indeed the other Rule 6 parties had an opportunity to cross-examine Mr. Mann on his evidence, including the note of the 26th of April, they didn't do so. Third general point is that sadly much of the submission is intemperate and in many cases simply wrong, and unfortunately it does Mr. Tamplin and indeed Poets no credit at all. Fourth, I will obviously, however, try to respond as best I can. Clearly, Poets not having cross-examined Mr. Mann on the particular issues, and much of this not actually being contained in Mr. Harman's evidence, or indeed Mr. Ng's evidence, which was on matters relating to funding and viability and so on, much of what is contained in these closing submissions, so-called, in fact goes beyond the evidence. So turning then to the document itself, paragraph 1, the suggestion that the funding position is smoke and mirrors is obviously entirely rejected. We have been entirely transparent on funding, and we have called Mr. Mann to explain the funding position and provide the update in relation to the recent Homes England further funding. Paragraph 3 of the letter appears simply to comment on some of the figures. It's not necessary for me to go into that. Paragraph 5 makes the suggestion completely improperly that the public funding of a piece of highway infrastructure might reasonably be termed a bung to housing developers. That's obviously entirely wrong, completely inappropriate. I'm frankly surprised that Mr. Tamplin, a former inspector, would even consider making such a suggestion. Paragraph 6 refers to the absence of information or evidence in Mr. Mann's proof on any further funding that the scheme may require. Mr. Mann explained very clearly in his evidence what the costs of the scheme are and the funding, and updated you, Madam, and the inquiry generally on that. The suggestion that the conditions which have been attached to the funding may affect the viability of the scheme itself and the financial viability of the council is founded on no evidence at all. Mr. Mann could have been asked questions about any of that. He was not. This is just baseless assertion from Mr. Tamplin. Paragraph 7 refers to the various departments and insinuates some impropriety by the government because two of the departments that had to be consulted by Homes England on funding are also decision makers. Of course, governments have perfectly proper mechanisms in place to deal with such situations, which happen frequently, as Mr. Tamplin surely knows. Paragraph 8 makes again a baseless further allegation, Poets being aware from reliable, reputable sources that further negotiations may be ongoing. Apparently the reliable, reputable sources don't know whether or not they are. I know absolutely nothing about this. Mr. Tamplin at Poets and the other Rule 6 parties present no evidence on it. I suggest you give very little, if any, weight to any such suggestion. Paragraph 9 refers to the whole saga that the council blundered into. That is, again, a complete misrepresentation of the facts by Mr. Tamplin. The council has been entirely, again, transparent about the evolution of the scheme, and you've heard the detailed evidence on the need for the scheme, how it has been embedded in the local plans, which were subject to examination by other inspectors. And again, this is just wholly inappropriate. Paragraph 10, the suggestion that the response from the County Council to objectors in their cases has been nothing short of disgraceful, again, intemperate and inaccurate. Completely inaccurate, Madam, then to, in effect, attack you. The suggestion that we have abrogated to ourselves the right to put in additional material and that we choose while objecting strongly to material objectors wish to put into the inquiry. Madam, you have decided on each and every document that has gone into the inquiry. No County Council document has gone in without your permission. We have only objected to documents going in where there was procedural unfairness, the attempts by poets and indeed other Rule 6 parties on occasion to put in documents after the evidence has been given by the County Council as promoter, and thereby removing from us the ability to respond through our own evidence. The procedural rules, as you have applied them, have been applied fairly, and they have applied to all parties. The suggestion that this has in some way blocked and frustrated the rights of objectors who are Rule 6 parties as if they had no status is therefore entirely without foundation. Even more extraordinary, the suggestion that we've interfered with the formal request under the Freedom of Information by trying to supply, I think it was the neighbouring parish councils, with information early is absolutely extraordinary. What we did in document INQ 67, informal response to traffic flow element of Roger Williams' FOI request, was to give Mr. Williams the data that he had asked for through FOI early so that it could be available at an appropriate stage in the inquiry. There was no commentary on that. We supplied the data in a way that was designed, as we said at the time, to be helpful, and interestingly, there was no objection from Mr. Williams or poets or any of the other parties to us trying to be helpful in that way. And this is another example of Mr. Tamplin misjudging, frankly, the very helpful way in which the council has tried to deal respectfully with the various Rule 6 parties. Again, the suggestion that the County Council had tried, we hope unsuccessfully, it is said by Mr. Tamplin, to prevent consideration of the effects of traffic generation by the scheme on air quality and health in the AQMA in Abingdon and on heritage assets of Newnham Courtney is just a gross distortion of the truth. We called witnesses on this. We explained in detail in relation to those things, air quality and health, why the modelling had been done in the way it was, and those witnesses were cross-examined. To suggest that we try to prevent consideration of the evidence in a context where we actually were the ones that called the evidence on those things, again, is just completely wrong. To suggest that these are perversions of the process and all reflections of the fact that much of what's required in the scoping opinion has been ignored is, again, completely wrong. The council responded appropriately to the scoping opinion, and where there were Rule 25 requests from the County Council as local planning authority, it responded in full to those. Paragraph 11 again, the suggestion that this is a disgraceful mess and relating to housing to employment in what is a rural area is, again, just intemperate and inappropriate. And the suggestion, again, in paragraph 10, that we have refused to respond to a repeated formal request for the issuing of a Regulation 25 request is again completely misunderstands the legislation. It is not for us as applicant to respond to a request to the County Council as planning authority, or indeed the Secretary of State or you, Madam, to issue a request. That is a matter for the decision maker. Originally, the County Council as planning authority, now you and the Secretary of State. So we have not refused to respond. This is, again, appears to be simply an attack on you and through you, the Secretary of State. We reject it entirely. The request was made, we've responded with our view. It is a matter for others as to whether or not there is a Regulation 25 request. Therefore, Madam, as I said at the outset, this closing submission does Mr. Tamplin and Poets no credit at all, and I'm frankly surprised that he has made it to you. But there we are. Those are my submissions in response.
Thank you. So I'm going to close the planning inquiry now. I've heard the evidence and I won't be accepting further evidence at this point. So what I suggest we do is if we move on to the modification and then we take a short break.
Yes,
So
Madam.
I understand it's quite minor. It's just about
Very
the footpath
minor.
numbering.
It will take us but a moment. So you've got there, Madam, a bound document which is an updated version of the modifications schedule you've had previously. Mm-hmm. And you've also got a series of plans, which is sheet 2 from both the order map and so from the CPO and the side roads order. You've got 2 versions of each of those that show the modified final position and in red script on another one, the actual modification that's been undertaken. It's purely, Madam, to deal with this footpath which changed on the 30th of
just
April.
The name of the...
Just the name of the footpath and the parish as well. So it's changed from 243/3/10 Harwell to 423/3/10 Western Valley.
Okay.
And on the bound document, the schedule itself, the key pages for you, Madam, are page 2, which deals with Schedule 2 and Sheet 2 of the side roads order. So that's an additional page from the version of this document that you've seen previously. And then page 10 of that same document. You'll note there, Madam, plots 2/3 and that series there. There is an additional entry there to deal with the change of the footpath. When we had the modification session, you were given a CPO plan for sheet 2. That should now be replaced by the plan that you have got because it didn't deal with the footpath. It did deal with the plot 2.2 that's at the top of that page, which was the rectification for one of the sliver plots for Network Rail. But the footpath was not dealt with at that point. The plans you have now deal with that following the change to the definitive map. Okay. They're the only changes, Madam.
Thank you. So I'm going to take a 15-minute break. Just check. Could we either during the break or at some point somebody just check with Joanna that we've got what we need on the website? And so if we return at 5:02 and hear the closing submissions in terms of the orders, unless there's anything else. Anything else? No? Right, well, thank you, everybody. I'll see you in a few minutes. Sorry.
Madam, thank you. These are now going to be the closing submissions in respect of the orders on behalf of the County Council. 2 or 3 things before I start. First, I would just like to acknowledge a huge debt of gratitude to Mr. Flanagan for doing all the hard work preparing these closing submissions, and to members of the County Council's team, both internal and consultant team, and my instructing solicitors for checking and reviewing things. I was allowed to be responsible for punctuation and typos, so if there are any typos, that's my fault. Second thing, I would say, you will see, Madam, you've got a paper copy. The closing submissions are some 79 pages long with over 260 footnotes. You'll be, I'm sure, delighted to hear I'm not going to read the submission. What I'm going to do is basically just give you a kind of guided tour of what it is. You're more than capable of reading it, and will, of course, in due course. The third thing I will just draw attention to actually is footnote number 1. Although it says closing submission in respect of the orders on behalf of the County Council as acquiring authority, footnote number 1 makes clear, obviously, that these closing submissions also deal with our closing submissions on the funding and viability aspects of the planning application, insofar as they're relevant to both the planning appeal, the called-in planning appeal, and the orders. And again, that will be clear from the relevant part of the closing submissions. The fourth thing I just need to tell you, and this is important, what you have is the version of the closing submissions that were printed early this morning. So they were sent to someone who had access to a printer, and they were printed early this morning. Late yesterday, we had a further document from Thames Water. So this is not the constraints document, it was the other document that we referred to. In the electronic version of this document, we've added a new footnote, which became footnote 116 on page 35. In fact, it's a long footnote. It goes over slightly into page 36. That does not appear in the paper copy, which was printed early this morning. We just thought it helpful. So obviously after that, all the footnote numbers get bumped by 1, but you just need to make sure that you have that, and I'll mention it as I go over that part, but it's not in this document. So what I'm going to do is summarise. Maybe I'll read some small parts, but just give you a guided tour of the closing. So what the closing submissions do is, in the first part of them, they address the case in support of the orders, including compliance with the CPO guidance, that's compulsory purchase and the Critchell Down rules, before then turning to the remaining objections. And there's a very clear sort of division, in effect, where we turn from those general things to the individual objections. Overall, we say, obviously, there is a compelling case in the public interest in the light of the urgent need for and substantial benefits of the scheme, and the remaining objections do not provide a proper basis not to confirm the orders, and any valid concerns have been appropriately addressed. The first part, Madam, then from paragraph 2 onwards of the closing addresses needs and benefits. And in effect, this is why we were very keen that both inquiries opened on day one, because our principal evidence on need and benefits was produced during the planning parts of the inquiries. And so what we've done in these few paragraphs here is just draw attention to that we gave our evidence and made our submissions on this in relation to the evidence in weeks 1 to 4, and we summarised all that in our closing submissions on the 23rd of April. We summarise in very, very high level there in paragraph 3 what we say the position was, but you have the detail. We also, my paragraph 4 here, deal with how we dealt with other matters, the other 13 main issues in those closing submissions, and the conclusion that the scheme does accord with the development plan as a whole. And paragraph 5, we simply make the point that the land and rights sought are needed for the scheme and do not exceed what is required. So that's an overview. From paragraph 6, we're dealing with alternatives, and again, that's very much an overview. This was dealt with in issue 4 of the planning inquiry, and again, we've relied on but don't repeat that case, and we've drawn attention to the relevant parts of our planning closing submissions, and there's no need for me to kind of go through that. From paragraph 8, we do deal with funding, deliverability, and viability. Now, this is a section that I suppose I could read, but I'm not sure that it is necessary. We've summarised here our case in relation to the evidence of Mr. Mann, including the additional note he gave, the funding update note. You'll see footnote 6, O-INQ12 is the note, and we've set out the position. I've responded, obviously, to the closing submissions from Poets, which touched on many of these issues, and you'll have taken a note of that. Obviously, they're not covered here because I didn't know about them. In paragraph 10, we respond specifically to the evidence of Mr. Ng in paragraphs 10A and 10B, and also to Mr. Harmon in paragraph 10C and 10D. And paragraph 11, we make explicit the point that we ask you, and indeed the Secretary of State, to take into account this section of the closing submissions on funding, deliverability and viability, both in the determination of the called-in planning application and in deciding whether to confirm the orders, given that that those issues have been raised in relation to both. What we then move on to do is pick up a number of discrete issues that we need to consider because of the CPO guidance. And paragraph 12 refers to paragraph 15 of the CPO guidance, and the test that obviously you and indeed the Secretary of State need to consider as to whether the scheme is likely to be blocked by any physical or legal impediments to implementation. And we deal with those issues. Their planning permission is being considered alongside. Traffic regulation orders anticipated to be made as required. No reason to consider any protective species licenses will not be obtained, and we've engaged with statutory undertakers, and we're taking on board their requirements as necessary. Attempts to acquire by negotiation, again, this is something referred to in the CPO guidance. we've drawn attention in paragraph 13 there to the guidance. A number of people have criticised us and said that we should have gone further in relation to negotiation with them before commencing compulsory purchase. We've drawn attention to the pretty clear guidance from government on that, which says it may often be sensible, given the amount of time required to complete the process, for the acquiring authority to plan a compulsory purchase order timetable as a contingency measure and initiate formal procedures, and that's what we've done. And in part that was necessary because of the urgency around this scheme, because of its importance for the housing and indeed employment allocations in the plan, and also by reason of the funding constraints. As we understood them, although those have now been relaxed to some extent, but we still need to get on with this scheme. And then what follows is a section that summarises at high level the attempts that were made, and you will be familiar with the fact that Mr. Mann, in a series of appendices in relation to major outstanding objectors, produces schedules of engagement, and I respectfully submit those do show very high levels of engagement. We've drawn attention, top of page 8 here, there was a suggestion from some objectors, Thames Water was one, that in some way it sort of didn't understand that compulsory purchase was in prospect, and we do firmly reject that. You will see in footnote 15 it makes clear that the requests for information, and we give the example of the one to Thames Water from July 2021, make clear that the requests, the formal statutory notices make clear that the request for information was in the context of the need to compulsorily purchase land under sections 239 to 260 of the Highways Act, and you'll see that in the text of paragraph 14. No one receiving the request can reasonably have been under any misunderstanding or misapprehension that compulsory purchase was being considered. So we go on there in paragraph 16, and 17 just confirms that we have made offers which are in accordance with the compensation code, and those reflect compensation as if the landowner's interest had been compulsorily purchased. The next section deals with human rights and equalities, again, as we're required to do under the CPO guidance. I don't think there's any need for me specifically to read that. Paragraph 22 touches on equalities impact assessment, which obviously has been undertaken, and you have that as a core document. From page 11, we just set out, I hope helpfully, the relevant provisions from the Highways Act in relation to the tests for side road orders and the bridge scheme, and we confirm that we have complied with that. There are outstanding objections, obviously, to the side roads order, but there is no outstanding objection, paragraph 26, to the bridge scheme. No objection from the Environment Agency. And so this is where the closing submissions pivot from those general matters that are required to be considered, and we've done that by reference to the CPO guidance, and here we start to turn from paragraph 28 onward to the remaining objections to the CPO and the side road order. And there's a table then at paragraph 28 which sets out the up-to-date position, and those objections struck through are the ones where objections have been withdrawn. And as you will see very clearly from this, and from what follows, we anticipate that others of these objections will be withdrawn. So we'll touch on this in relation to Network Rail, for example, but May's property, number 7 in the list, Thames Water, possibly, although that may be further away because of the need to bring that agreement about, but also then Gale Trust, number 27, and again, RWE, we're also working on agreement there. It may be, and we hope with some of those that I've just mentioned, there could be a withdrawal before the 20th of May deadline you've given, but I'm afraid that some of them will not be, in which case any withdrawal of objections will be reported directly to the Secretary of State. So from paragraph 29 onwards, we start to deal with the remaining objections, so just the remaining objections, and we start there with objection 1, Network Rail. We summarise in paragraph 29 what the objection is and where we have got to. It's very clear from the bottom of page 13. Once legal agreement is finalised, it will secure the land and new rights that the acquiring authority requires. Will therefore remove the need to compulsory purchase certain land. Modifications are being sought. Refers to the confirmation from Network Rail in a letter to the Inspectorate of 25th of April, and that we will update you once the agreement is finalised. There is a Section 16 representation to the Secretary of State in relation to this objection, but it's anticipated that this will be withdrawn. So we've dealt with it fairly briefly in the context that Network Rail did not turn up at the inquiry, but I hope that's helpful. Objection 2 deals with Allen and Penny Aries. We've summarised again there what their plots are, what the nature of the objection is. These are plots, they're subsoil plots, and we've summarised there our position on the various points raised by Allen and Penny Aries, and we conclude at paragraph 37 that for all the above reasons, the impacts of the land take on Mr. and Mrs. Aries are negligible, given that the plots in question are subsoil under the highway. Any negative environmental impact on Mr. and Mrs. Aries as a result of the scheme are very limited. Impacts looked at overall are significantly positive due to the large reduction in traffic flows and noise. The objection provides no reason not to confirm the orders. Objection 6, Mr. Smith, he has an interest in a plot in relation to a right-of-way, and he's concerned about continuity of utility supplies. We deal with that and then conclude at paragraph 42. The scheme will, in fact, improve the safety and convenience of access to Mr. Smith's property. The environmental effects on Mr. Smith's property are limited, being mitigated and minimised in accordance with policy, and his objection provides no basis not to confirm the orders. Objection 7 is May's Properties Limited, and we record at paragraph 43 that May's Properties has written to the inspector to confirm, given the advanced state of negotiations for a private agreement, it's decided not to present evidence, and it explains that once agreement is reached, its objections can be withdrawn. Paragraph 44 sets out that I summarised yesterday the outlined the proposed agreement. Paragraph 45 records that the agreement, as I explained yesterday, does not require any modification to the order, and nor is there any need for a bespoke planning condition relating to the objection. And once completed, MPL will withdraw its objection, and we anticipate this should be completed by the 20th of May. But we have to accept, obviously, that may not happen, and obviously, there is no guarantee that the agreement will be signed, although we very much anticipate that that is the case. And so the remaining paragraphs in relation to Mays Property Limited deals with our case on the basis that that there is no agreement, or in any event no agreement by the time your 20th of May deadline is reached. And so we go through the various issues that were raised. So you can see heading at paragraph 48, prematurity, 49, funding. From paragraph 50 onwards, quite a long section on attempts to acquire by private treaty, where we summarise the evidence. Paragraph 58 deals with land, the point that land is not required for the highway. So this is the distinction between plot 16B and 16A, and we go through the issues there. I don't think I need to read through all of that. From paragraph 65, no requirement to permanently acquire the land. In part, we've covered this, that there was an issue that appeared to arise earlier where it was said, well, hang on, why is it, if we only need this land temporarily, have we acquired it as freehold? And the answer, obviously, is that there is no power in the Highways Act for us to acquire land temporarily. Contrast certain other acts and indeed development consent orders, which many people may be familiar with, where you can take a right to acquire certain rights on a temporary basis. That doesn't exist in this case, so we deal with that. Loss of rights, this is the right to access the land and whether or not it becomes landlocked. And we deal with this, and Mr. Blanchard yesterday also explained the proposals there, and this then gets tied up with the form of private access into what will be Mays Properties' retained land after the Backhill Lane roundabout has been constructed and the southwest arm constructed, and the various schemes. We went through them yesterday, the sort of Appendix A scheme, the Appendix C scheme, and the Appendix D scheme, all of appendices to Mr. Roberts' evidence. I draw attention in paragraph 70 to Mr. Roberts making it very clear that the Appendix D, which is the supermarket scheme that connects into the Backhill Lane roundabout, southwest arm, is described as Mr. Roberts' client's preferred scheme. And I suggested there that makes clear that MPL is not opposed to the Hif1 planning application or CPO in principle, but there's an issue over the private access. And, it's anticipated that the agreement that's been reached between the parties provides a sort of settlement on that is acceptable to both parties. So in conclusion, paragraph 71, I've said there, whilst it's anticipated this objection will be withdrawn. In the event that it is not, it's OCC's case that MPL's objection provides no basis not to confirm the orders. Both of the plots are required for the scheme, and in fact, plot 16A is required, the fact that plot 16A is required temporarily for construction rather than permanently is no proper basis to object. Once the plot is no longer required, it can be re-provided back to MPL. Access rights are preserved to the MPL land, and the scheme will significantly, in fact, enhance the quality of the access as compared to what exists at present, and indeed what is proposed in the T-junction arrangement. OCC has negotiated extensively and diligently with MPL, and the concerns regarding funding and prematurity are obviously unfounded, so we deal with that. Objection 9 from paragraph 72 deals with the Oxford Field Paths Society and the Ramblers, and you heard obviously from Mr. Nicholas Moon and Mr. David Godfrey in relation to those objections on day 19. And we summarise there from paragraph 73 the first concern and Bridleway 3, and from paragraph 76 the second area of concern, which is relates to sections of footpaths 3 and 6 at Clifton Hampton. And we conclude in that in paragraphs 77 to 79, saying that we have complied with the SRO tests, and in short, that there is no reason not to confirm the order. Objection 11 relates to Thames water. Again, our overall view is that the objection does not provide any proper basis not to confirm the orders. I mention it later, but stress that there is no Section 16 objection in this case. So we deal with things under the various headings, again, which I'll just simply summarise. No adverse impact on Thames water, and we're dealing first with the Thames water plots outside the northern parcel. So there were two, I think it was, remote plots of land, 1711 I and plot 924, and there were no objections in relation to 1714A and 1714B. So that deals with the plots that were outside the northern parcel, no objections there, or at least in relation to 1711I, that's one that can be overcome. Then from paragraph 84, this deals with the northern parcel, and we deal with this in some detail. Again, I will just draw attention to it, I won't go through it. From paragraph 91, we just draw attention there to Mr. Patton's evidence given in cross-examination that to meet its needs to expand the Culham sewage treatment works, there were three options, and those are then summarised in paragraph 92, 93 and 94. So the first of them is an agreement whereby we acquire land next to the Culham treatment works and then provide it to them, and that's what the parties are working on. The second is that, of course, Thames Water has compulsory purchase powers in relation to that land just to the east of its existing sewage treatment works, and there is a willing seller here. The landowner is perfectly willing to treat with us, or indeed Thames Water, for the use of that land for an extension. And the third option in paragraph 94 is a non-Culham solution, and we deal with that. And that may not be what Mr. Payton described as his preferred option, but it doesn't cease to be an option, and you can see there, paragraph 97, we draw attention to the fact that Thames Water's submissions say only that the expansion into the northern parcel is the preferred option, notably does not dispute that there are other alternative options. So we go on. I don't, again, need to read through all of that. Paragraph 101 deals with Thames Water's reliance on the DEFRA letter. Perhaps the important point, which we make in the written submission here, the important point to make here is that obviously DEFRA didn't have available to it the full facts. It didn't have available to it the fact that there are actually other alternatives, including the land to the east, and therefore, it does seem to us that little, if any, weight can be put on that DEFRA letter, which in any event is not given in the context of Section 16. It's at the end of paragraph 101F, Madam, that we've inserted this new footnote, and we did it hastily, and it seems to me that this is an appropriate place for it. There could have been other places. I'll read to you what it says, but it is in the electronic version of the submission. What it says is this, so it's a new sort of inserted 116 that sort of slots in before what was 116 in the printed version. It says TWUL has submitted a note to the inquiry entitled TWUL's PR24 Business Plan Growth EC, received by OCC late on 8th of May 2024, that's yesterday, the penultimate day of the inquiry. The note takes matters no further. It states that Culham STW will need expanding in order to meet this demand, but as Mr. Payton clearly explained in oral evidence and as set out in these closing submissions, TWUL has multiple options to meet the demand, and if the northern parcel is not available, there is no suggestion that an alternative will not be found. The note also explains that only early start funding has been allocated in relation to a Culham treatment works expansion option at present, and then quotes, which is being used to develop more detailed solutions before the start of AMP8. Those detailed solutions, accordingly, do not yet exist, and in any event, the option of using the land adjacent to the Culham treatment works identified in the Statement of Common Ground would provide for the expansion. So we don't think the note really takes things any further forward, although in certain respects it is helpful to us. The printed version that you had from paragraph 102 goes on to deal with negotiation. This is quite a long and detailed section because of the criticism by Thames Water of the County Council. We entirely reject that. Indeed, our position in general is that to a very large extent Thames Water has been the agent of its own misfortune. For a long time it simply didn't seem to engage either with the safeguarding or the planning application or even the early stages in relation to compulsory acquisition, where clearly we were requesting information in the context of compulsory acquisition. Be that as it May, our overall position on all of this is that we've complied with the CPO guidance, and clearly more recently, once Mr. Smith became involved, negotiations did intensify significantly in relation to compulsory acquisition, and that's been helpful. From paragraph 1 to 3, we deal with alternatives, and this is not alternatives in relation to other sewage treatment work expansion locations, but alternative locations for this section of Hif1, and we respond to that. And from paragraph 1 to 7, we set out our conclusions on the TWUL objection. I'll perhaps just read through those. We say TWUL's objection provides no proper basis not to confirm the CPO. In terms of impact on Thames Water and sewage capacity in the area, there are multiple potential options for meeting the need for expanding capacity which do not rely on Thames Water retaining the northern parcel of the Culham treatment works. Most obviously, expanding into the neighbouring land, either by private agreement or using Thames Water's CPO powers, or alternatively by expansion of one of the other 5 treatment works within a 3-mile radius. Thames Water have only recently clearly identified the need to expand, and additional capacity does not need to come online until 2031, and that's in a sense consistent with this indication in the recent document that early start funding has been allocated to develop more detailed schemes. Clearly, things at Culham are a very early stage. 1 to 9, in terms of negotiation, OCC has extensively engaged and negotiated with Thames Water. Thames Water acquiesced in the safeguarding of their land for the Hif1 scheme and did not object to the planning application. Thames Water now makes what we think is remarkable and frankly misconceived suggestion that prior to December 2022, OCC was asking Thames Water to read between the lines in respect of the need to acquire the northern parcel for the Hif1 scheme. And Madam, Thames Water at no point had to read between the lines. They simply had to read the words of the statutory development plan, which safeguarded the northern parcel for the road and showed it on the safeguarding plan. Planning application, which Thames Water were notified of as landowners, showing the same thing. And Mr. Moon explained the scheme to Thames Water in 2021 and raised the need for land acquisition. After, there's also the requisition plan again from July 2021. After December 2022, there's no dispute that there's been substantial engagement for the last 16 months, Thames Water having stayed silent despite safeguarding planning application and engagement in 2020 to 2022, then raised an objection very late after the CPO was made. And even then it was not until late 2023, early 2024 that Thames Water began to provide sufficient information to the County Council to enable it to devise a worked-up solution on neighbouring land. And, in the light of all of that, it can't be said that Thames Water objection justifies not confirming the CPO, with the consequence that thousands of homes and jobs planned in the development plan for the area, which the scheme would facilitate, cannot go ahead. Then the objection 12 is Appleford Parish Council, and 28 is the neighbouring parish council's joint committee. The Appleford Parish Council and the joint committee are not landowners, and the objections are very largely the same as those advanced by the joint committee at the call-in inquiry, and I've listed there the various issues And we've responded to all of those in detail in our evidence under issues 1 to 14 of the call-in inquiry and in our closing submissions. And we don't need to repeat all of that. They've alleged that there's, para 133, inadequate funding for the scheme, and also raised concerns about deliverability. Those issues have been responded to above, and they are unsubstantiated. As Madam, you rightly pointed out, although Mr. Tamplin for Poets gave a closing submission on these things, Poets didn't have an objection to the order and didn't call evidence on these things, but I've dealt with those closing submissions. They contend, Appleford Parish Council and the Joint Committee contend there's no compelling case in the public interest. Obviously, we very much reject that. And in paragraph 135, we say the objections of those parties overlap completely with the points raised during the call-in inquiry. They're without merit for the reasons which we've set out, and they provide no basis not to confirm the order. And then objections 15, 16, 17 and 18 all relate to Mr. Mockler and Ms. Marsh as trustees of the Milton Manor estate, Mr. Mockler personally, and a further one, 18 again, Mr. Mockler and Ms. Marsh as trustees of the Milton settled estate. And again, we've identified what the objections are. I should just draw attention to the fact, which isn't made explicit here, but so it just needs to be noted, that paragraph 138 and 139 deal with Mr. Mockler's points reiterated this morning about the widening of the A4031 to dual carriageway. In a sense, those things raise also planning issues, and therefore, insofar as that needs to be considered in the called-in inquiries, these paragraphs represent our position on Mr. Mockler's the issues that he raises. We've dealt with them here as part of his objections to the orders, but that they may be relevant to those other matters as well. Para 149 on page 49, we set out here our conclusions on the objections by Mr. Mockler and Ms. Marsh in relation to all their various objections. We say to the extent that the objectors raise planning objections to the schemes or challenge the need for the scheme, those matters have been dealt with fully in OCC's evidence and closing submissions for the call-in inquiry and are without merit. And again, I just emphasise para 138 and 9 are part of that. To the extent that the objectors allege an unacceptable impact of the proposed development for the North West Valley Park allocated site, those objections are also without merit, and the scheme is in fact entirely consistent with the allocation in the development plan and will facilitate, not harm, the development of the site. And for those reasons, the objections provide no basis not to confirm the orders. Then objection 19, this was from New Farm, the occupiers of New Farm. Originally, the County Council didn't have any information about the occupiers of New Farm because Mr. Mockler didn't provide their details, and he expressly told the County Council that his tenant should not be contacted. It became clear subsequently, however, that the occupiers are Mr. Page and his family, who appeared at the inquiry on day 20, and Mr. Page and indeed Mr. Mockler confirmed that Mr. Page lives at New Farm. Mr. Page had a number of concerns about the road relating to noise, disturbance and safety and so on, and we have responded to those, and we set out our position. And paragraph 154, we conclude that the concerns based on noise, disruption and safety raised by the New Farm objectors will be appropriately addressed by mitigation measures. They do not show any unacceptable impact and do not provide a basis not to confirm the orders. Then objection 27 is the Gale Trust, also referred to sometimes as, by us here as the trustees. And the trustees have also, if I may say so, very helpfully written to the inspector to confirm that, given the advanced state of negotiations with OCC for a private agreement, they've decided not to present evidence in person at the inquiry. They explain that once agreement is reached, their objection can be withdrawn. And I've identified here, as indeed I identified orally yesterday, the broad outline of the proposed agreement. This agreement, contrast May's property, does contemplate a modification to the order, and it is anticipated that that will be completed and the modification requested and the objection withdrawn before the 20th of May deadline. We do go on to say here that although it's positive negotiations have reached this stage, the trustees have not yet withdrawn the objection, and therefore we need to go on and deal with the objection. Paragraph 158 just simply identifies, these various plots of land, the pink land and the green land, and you'll remember also there's a larger land ownership by the trustees, and that land to the north of the green land is referred to as the retained land. So the closing submissions from paragraph 160 deal with the need for the green land, and this is all on the basis, as we have to assume for these purposes, that there isn't an agreement or isn't an agreement in time, and you need to report. So it deals with the need for the green land. From paragraph 166, we deal with the development potential of the green land, and we point there to its planning status, and make clear at the end of paragraph 169 that it's obviously not for you, Madam, or indeed the Secretary of State, to opine on the future planning potential of the land. And that's particularly so in the context where the local planning authority, Vale of White Horse, has no opportunity to express a view. The land is agricultural land. There may be some developer interest in it, and that's as may be, but its planning status at the moment is quite clear. We go on from paragraph 171 to deal with the ongoing access to the trustees' land. This is, retaining access during the period that we're using the green land for construction. From paragraph 174, this deals with the standard of the replacement access. This is the point about whether or not we should be providing a replacement access which is suitable for future development of those fields, or simply replacing the existing agricultural access. And we've made it very clear that that we should be replacing it on a like-for-like basis. From 176, we deal with negotiations, and there's an extensive section there. 184 deal with compensation. I hope not unfairly, but some of Mr. Broomhead's evidence seemed to be directed towards issues that really relate to compensation and development value and those sorts of things. Clearly, compensation has been discussed during the engagement with the trustees, and we acknowledge that. But any development value of the land is not really a matter for the for you, Madam, or the Secretary of State, as is well established. To the extent there is a dispute about compensation, ultimately that's a matter to be resolved by agreement or by reference. Or by a reference to the Lands Chamber. So, conclusions on the trustees' objection, we say whilst it is anticipated that this objection will be withdrawn, in the event it is not, it's the County Council's case that the objection by the trustees provides no proper basis not to confirm the orders. The green land is required for a construction compound, and is the only suitable area available as confirmed by the uncontradicted evidence of Mr. Blanchard. If, as is anticipated, the green land is no longer required after construction, it will be offered back to the owners in accordance with the Critchell Down rules. This is obviously absent some agreement, so I'm assuming here we've compulsorily acquired it. It will be offered back in accordance with Critchell Down. Access to the trustees' land will be preserved during construction and operation. Replacement access proposed and secured by the side road order is equivalent to what exists, and there is no basis to suggest that enhanced access should be re-provided to facilitate future development on the trustees' land, which currently does not have planning permission and concerns a site which is not allocated in the development plan. The trustees' suggestions of inadequate negotiation are wholly misconceived. Engagement and negotiations have been extensive and continuous and are more than sufficient to show compliance with the CPO guidance. We then get to objection 31, RWE. RWE has obviously, as I indicate here, got a number of land interests around the Didcot Science Bridge Road that are needed for the scheme, some temporary, some permanent. There is an objection to the CPO and SRO based on potential impact. There is no Section 16 representation, or no valid representation. So this is not the case, therefore, that the CPO cannot be confirmed without a certificate from the relevant minister that the land in question can be purchased without serious detriment. RWE seek a private agreement containing protective provisions in respect of access, drainage, utilities, and the counties are amenable to entering such an agreement, and HESA terms have now been agreed. The RWE won't, however, withdraw its objection until the agreement is signed, and therefore, Madam, until that happens, unfortunately, both we and you have to deal with the remaining objection, despite the fact that we have actually reached agreement in heads of terms. So we go on and deal then with essentially the fivefold points raised by RWE. The first is 24/7 access. We deal with that and how that will be maintained. The second, from paragraph 191, deals with the standard of access to be provided. The third point from 192 is about the gatehouse, and we set out our position in relation to that in detail. Fourthly, paragraph 194, drainage, and this relates to the westerly of the two drainage lagoons and the need to replace a lagoon before the existing one is removed. And then fifthly, utilities. And again, we deal with that, and our position is that there is no reason in any of those not to confirm the order. The next heading, securing the commitments, starts by saying that all of RWE's requirements will be met. That's clear. And the County Council has committed to doing so and has adduced expert evidence that it's feasible to do so within the highway design. None of that is disputed. Mr. Trigg's evidence doesn't dispute any of Mr. Blanchard's evidence as to how all 5 of the operational issues which he raises will be addressed as part of the design. And Mr. Trigg doesn't say what Mr. Blanchard proposed is inadequate. And we then explain that RWE's sole point of dispute, leaving aside certain comments about negotiation, is about securing the commitments, and we go on then to deal with this at some length, and it's in this context at paragraphs 206 and 207 that we deal with the point about the now proposed planning condition and certain additional wording in relation to the condition on the CEMP. And you heard from Mr. Flanagan this morning. There have been some further comments from RWE for which we're grateful, and those are acceptable to us. From paragraph 211, we deal with engagement and negotiation. And again, there's considerable text here because we have been criticised, and we say completely unjustifiably criticised, and therefore we go into some detail to demonstrate that. Before turning at paragraph 229 to alternatives, and we deal with that final issue before we set out our conclusions on RWE's objection at paragraph 232, where we say this: RWE's objection provides no proper basis not to confirm the orders. The orders can be recommended for confirmation by the inspector and confirmed by the Secretary of State, regardless of whether or not the private agreement between OCC and RWE is signed. RWE's concerns that their operational interests are protected and that their ability to further develop their land is not prejudiced are all fully addressed by the design of the scheme and the steps in respect of access, sequencing and protection of utilities that will be put in place during construction. They will be secured through conditions in construction contracts in the usual way, as they are for other landowners who may require ongoing access or other provisions. The County Council will be able to provide control in that way. The evidence is clear that those operational interests will be protected. To the extent that the County Council's commitments in that respect need to be further secured, a planning condition or conditions is entirely capable of providing adequate security. RWE's criticism in respect of negotiations are wholly unsubstantiated and indeed unevidenced. The County Council has been liaising with RWE for many years in respect to the scheme since early 2020, and since early 2023 has been in detailed negotiations with RWE over land acquisition. It has been RWE's insistence on using a Section 106 agreement for land acquisition, despite there being no certainty if or when necessary planning permission will be granted, rather than a normal bilateral private agreement, which has slowed matters considerably. The fact that RWE has now abandoned that suggestion and has agreed heads of terms for a private agreement is recognition of the problems that their former approach was causing. RWE is wrong to suggest that removal of RWE's plots from the CPO will not prejudice the scheme. That would remove OCC's ability to guarantee the necessary land assembly in the necessary timescale and would fundamentally just jeopardise the scheme, its programme and funding. There is no valid representation under Section 16, such that the restriction in that section does not apply. So that's where we end dealing with the individual objections, and then there are just these very brief sections at the end. Modifications, table of modifications has been provided in respect of the CPO and SRO and discussed in the modifications section, and indeed some very minor further modifications were discussed today. The County Council invites the Secretary of State to confirm the orders with those modifications, including further updates subsequently provided or to be provided, and I have in mind in particular, obviously, Gale Trust. Compelling case in the public interest. The evidence before the conjoined call-in and orders inquiries overwhelmingly demonstrates that there is a compelling case in the public interest for the scheme. The need for and benefits of the scheme can only attract very substantial weight. The adverse environmental effects are few and far between, and overall the environmental effects are significantly positive. There's been no serious challenge to the compelling case in the public interest for the scheme by any objector. To the extent that there is any in-principle opposition to the scheme, for example by Mr. Mockler, the points of objection raised are on evidence and have been shown to be wholly without merit by the evidence put forward by the County Council. The remaining objectors to the orders are principally concerned with protecting their particular private interests, to the extent that Thames Water and RWE suggest that, as statutory undertakers, they raise concerns of wider public interest. Those concerns have been appropriately addressed and do not provide a reason not to confirm the orders. A wider view also needs to be taken. This is a £330 million scheme. It has significant central government support and funding, and has the strong backing of both the district councils and very widespread support from local organisations and people. And it is essential to enabling tens of thousands of houses and jobs planned for in the development plan to go ahead, along with facilitating the growth of the world-leading research at the Cullum Science Centre. The points raised by the remaining objectors need to be seen in that context. None of the objectors' concerns come close to providing a proper reason not to confirm the orders, which would prevent this hugely important scheme going ahead. This includes Thames Water's objection based on the vacant northern parcel of the Cullum Treatment Works, when there are clearly other options to expand the Cullum Treatment Works. RWE's concerns about ensuring it has continuity of access, service, drainage in respect of its operations, which OCC has committed to maintain. MPL and Gale Trust's objections based primarily on maintaining access and on retaining land required for construction once it is no longer required, which issues the County Council has shown will be addressed to the satisfaction of the landowners and which plainly do not present any particular difficulties, and the other detailed points raised by other remaining objectors. The objections are heavily and comprehensively outweighed, and the compelling case in the public interest is clearly made out, and therefore, in conclusion, Madam, for all the above reasons, the County Council asks that the orders be confirmed subject to the modifications, and those are the closing submissions for the County Council.
Thank you,
I was
Mr.
hoping
Humphreys.
to finish by 1 o'clock, and I have just.
Right. I think I'll adjourn the inquiry because you've got another point.
I just say, just before you adjourn the inquiry, and I'm sure I say this on behalf of all the parties, both objectors, ourselves, and the various local authorities, we would like to thank you for the way in which you've conducted the inquiry, which has well, it's been very helpful to all parties, and we are genuinely grateful. So I would like to say thank you.
Okay, thank you.
I should say that goes also for Ms. Vincent at the back.
Absolutely.
Thank you.
I don't think we could have managed without. So thank you for that. So I'm going to adjourn the inquiry in order to. I want all those documents in by 20th. I will close it in writing on the 20th of May. And that's any withdrawn objections. I can't remember what. And the hopefully the Thames Water document. I don't know. Joanna, have we had an update? No? Hopefully that will be with us by tomorrow. And then if you could respond.
Thank you, Madam.
Try and agree before you respond, I suppose.
Yes, hopefully it will be sent to us first, so that we can agree it if it is something that can be agreed, and insofar as we need to comment, we'll try to do so, you know, as succinctly as possible, and very much framed around what has gone in. We will not widen it out into other things.
Okay. Thank you. So I don't think there's anything else. I think we've dealt with everything. So thank you, everybody.
Thank you.
Okay.